Today marks a pivotal moment. In the U.S. Senate, the session is finally moving into the section of the bill that addresses the National Firearms Act. Known as the NFA, this part of the legislation is drawing major attention from firearms owners, industry professionals, and legal observers alike. Welcome to Firearms Zone. In today's update, we're covering two key developments currently making waves in the firearms community. First, we'll break down the latest ruling from the Ninth Circuit Court of Appeals on California's one-gun-a-month law. Second, we'll provide a status check on the current effort to roll back portions of the NFA through legislative action, specifically through provisions like the Hearing Protection Act and the SHORT Act. Whether you're following regulatory trends, monitoring Second Amendment cases, or simply staying informed on how federal and state-level legislation impacts firearm ownership, this is information worth tracking. Legal update. Federal court strikes down California's one-gun-per-month law. In a landmark decision, the Ninth Circuit Court of Appeals has struck down California's one-gun-per-month law as unconstitutional. The case, Wynn v. Bonta, was brought forward by the Second Amendment Foundation and the Firearms Policy Coalition, challenging the state's restriction on how frequently law-abiding citizens can purchase firearms. In a unanimous 3-0 decision, the panel ruled that the law violates the plain text of the Second Amendment. The court made clear that the right to keep and bear arms includes the right to acquire them, without arbitrary time-based limits. From the court's opinion, the Second Amendment protects the right of the people to keep and bear arms, plural. Not only is arms stated in the plural, but the term refers to more than just guns. It includes other weapons and instruments used for defense. The ruling also pointed out that California failed to present any historical precedent to support such a limit. There is no recognized tradition in American law of restricting firearm acquisition to one per month. The decision directly contrasts with other recent federal rulings, such as one that upheld age-based purchase bans, setting the stage for a broader constitutional debate. In this case, the Ninth Circuit drew a clear line. The Second Amendment protects not just possession, but acquisition as well. Brandon Combs, president of Firearms Policy Coalition, responded by saying, "The right to keep and bear arms cannot be limited by an arbitrary cap on how many firearms you can purchase. We wouldn't tolerate a law that says you can only buy one Bible per month. We shouldn't tolerate it for guns either." Historically, gun rationing laws like this one were promoted as a means to combat so-called straw purchases or slow down criminal access to firearms. But critics argue they disproportionately burden legal owners without meaningful results. California is not alone. States like New Jersey, Virginia, and Washington, D.C. have explored or implemented similar restrictions. At the time of this report, California has not yet stated whether it will seek an en banc review or appeal the case to the Supreme Court. For now, the ruling stands as a major legal victory for gun rights advocates and could serve as a precedent in future challenges to acquisition-based restrictions across the country. Legislative tracking. National Firearms Act rollback under Senate review. As of this recording, the United States Senate is in the process of reviewing key sections of a comprehensive legislative package, sections that could directly impact federal firearms regulations that have been in place for nearly a century. At the center of the discussion are two specific provisions: the Hearing Protection Act and the SHORT Act. Both proposals aim to roll back restrictions found in the National Firearms Act, also known as the NFA, which was first enacted in 1934. That law imposed strict controls on suppressors, short-barreled rifles, and other items considered unconventional at the time. Since then, these categories have remained heavily regulated under federal law. Under the current proposal, suppressors and certain short-barreled firearms would no longer be classified as NFA items, and instead would be treated like standard Title I firearms, meaning background checks would still apply, but additional taxation, registration, and delays would be eliminated. Right now, the Senate parliamentarian is reviewing the bill through a process known as the Byrd Bath, part of the larger Byrd Rule. This step determines which parts of the bill meet federal budget guidelines and which may be challenged or struck out. While the parliamentarian's review is procedural and advisory, it can heavily influence what stays in the final package. A full Senate override is possible but has not occurred since the 1970s. Sources close to the process confirm that, as of this morning, the NFA-related provisions remain in the bill. Advocacy organizations continue urging citizens to contact their senators at area code 202-224-3121 to express their views before final votes are cast. Supporters of the changes argue that modern suppressors serve primarily as hearing protection tools, especially in enclosed spaces or for new shooters. Likewise, they say that shorter-barreled rifles and shotguns provide practical self-defense options for individuals with smaller stature or physical limitations, groups often overlooked in federal gun design standards. While the outcome remains uncertain, what is clear is that this is one of the most serious legislative efforts to revise the NFA since its original passage in 1934. A final Senate vote could take place within the next several days. If passed, the bill would move into reconciliation with the House version before heading to the President's desk. We will continue tracking developments and providing updates as this process unfolds. We'll continue monitoring both the legal and legislative fronts closely. The court ruling in Wynn v. Bonta has the potential to influence how other states approach firearm acquisition laws, especially those considering similar monthly purchasing limits. Meanwhile, the developments around the National Firearms Act and the inclusion of the Hearing Protection Act and Short Act in current legislation represent one of the most significant federal-level efforts to reform firearm classifications in decades. As always, Firearms Zone will keep tracking the facts as they unfold. We're here to provide clear, reliable updates on the laws, policies, and decisions that affect firearm owners across the country. If you found this report helpful, stay connected by subscribing or following the channel for future coverage. Thanks for watching. Stay informed, stay responsible, and stay safe.